Hi, I'm attorney Roger P. Foley, and today I want to talk to you about Florida Statute 741.31, subsection 4A. What is that? That is a violation of a domestic violence injunction. What is that? When you violate a restraining order. When you have a loved one, a family member, and you're going through tough times. Maybe that person files for a restraining order, what's commonly called as an injunction in the state of Florida, where they're saying, hey, I'm scared of this person, I don't want to be around them. Maybe it's your husband, maybe it's your wife that's filed this injunction. The manner in which you get an injunction is pretty simple. An individual files a petition, which they can do without an attorney. They can do it with an attorney as well. They file a petition, they say to the judge, there's been an act of domestic violence, there's been an act of stalking, there's been threatening, there's been a unlawful touching, a battery, and I'm scared and I'm fearful. You go to court, you tell your version of events, and the judge makes a decision. Let me tell you straight out, folks. Judges err on the side of caution. What does that mean? That means that unless your injunction, that your claims are just ridiculous, if you stand up in front of the court and you say, this person has hit me, this person has threatened me, I'm scared of this person because of those reasons, you have a very high likelihood of getting an injunction granted, having a restraining order granted. So then what happens? Well, if you're the respondent, now the person who petitioned the court is called the petitioner, the respondent, the person who the injunction is against, who can no longer come within a certain amount of feet, let's say 500 feet of the petitioner, that person can no longer have a firearm. If they had a firearm, it needs to be surrendered. Also, an injunction shows up almost like on a criminal record. If someone does a background check on you, a domestic violence injunction is coming up. Now, having a domestic violence injunction is actually civil. It's within the family court. It's not a criminal, it's not a crime. However, it is looked upon by law enforcement and just the general community as someone who's dangerous. So what happens when you have an injunction placed against you? Well, it could be a very short time. It could be a few months. It could be a year. It could be 2 years, 5 years, 10 years. It could be permanent. So that means during that time, you can't call the person, the petitioner. You can't write the petitioner. You can't stop by. You can't wave to the petitioner if you see them. You can't email them. You can't social media them. You can't do in any manner. You cannot contact them. That includes your family. So let's say your brother. You say, hey, Bill, could you call the wife? I really want to get back together. I love her. I love the children. I want to see them. And Bill does that. Well, Bill can get in trouble, but more importantly, you can get in trouble. How can you get in trouble? Because you're not allowed to contact even through a third person. So, what's one of the most common charges? A violation of a domestic violence injunction, violation of the restraining order. It's not just against the victim, not against the petitioner, the person who claimed it, your loved one who kind of doesn't want to be around you anymore. It's against the court because it's almost like quite frankly, it's an FU to the court. Listen, you ordered me not to talk to this man, to this woman, but I did so anyway because I felt that it was important. I had a reason. Now you're facing, Now you're facing a crime. So what does the state need to prove? Let's talk about it. All they have to prove is that there was an injunction or restraining order put in place. That's pretty easy. They just pull the record from the family court, And that you knowingly, intentionally, and purposely violated that injunction. If they can do that, then you're going to be charged with a misdemeanor crime. It's a first-degree misdemeanor, punishable by up to 1 year in the county jail. There's also a fine involved. And you can also be charged if during the course of that injunction you're found to have a weapon in your possession. Because that in itself is a violation of the injunction. So it's not just contacting that person, which is usually the main core of why this charge comes about, but also if you're in possession of a firearm. Even if you have a concealed firearm permit, guess what? If you get a domestic violence injunction, a restraining order placed against you, that permit is canceled, and you have a duty to return that back, that document back to the government. So I'm attorney Roger P. Foley. That's talking to you a little bit about domestic violence injunctions and the violation of those injunctions.